Good morning, everybody. I'm really flattered and honored to be here today in the capacity of the President of CCJE, exactly taking that office from the 1st of January. I must say that I would like also to thank to the faculty and especially to Justitia, who has a perfect know-how to organize the meetings. I remember 2 years ago the meeting in Gdańsk of the European Association of Judges, where that was perhaps the first meeting where the issue of Poland has been mentioned at the international forum. And from that time till now, through the Association of Judges, international judges, through the Council of Judges in the Council of Europe, we are dealing with this issue. The CCJE is a unique body in the frame of Council of Europe because it is formed only by judges. The judges there are not representing their governments, they are representing themselves. And so far we produced 20 opinions which are dealing with the different issues of the judiciary, from the general independence as opinion number 1 till the last opinion which was about the role of courts in unification of the case law. And
the microphone
sorry?
Closer, yeah.
Okay, sorry. And the next opinion will take care about the judges and corruption. So from that time, we started as a very shy and not important body of Council of Europe, but for now, nowadays, the Council of Ministers and all this Grammy of administration in the Council of Europe relies on our work, and I think we managed to make our importance even more because of the essence of the work. And allow me now to sit to go to my topics. Speaking about the guarantees and the standards of Council of Europe regarding the independence of judiciary and the working of judicial system, it has to be first of all stressed that citizens expect that judges will act and rule in accordance with the law and with the applicable procedural rules based solely on the elements brought before them, without any influence or external pressure, and with no threat of sanctions or expectation perceived for personal gain. It should be underlined that the crucial guarantee of judicial independence is the judge's security of tenure and the rule that they shall be promoted or transferred, or let's say transferred and promoted with their free consent. So that statutory guarantees of judicial independence are not enough to preserve the independence of judiciary. So it is a joint effort. Once the judges have to preserve their independence and their role in society, but in other hands, the state has to make such kind of environment to make it able, because it is not only on judges to be independent, it is also on the state to create such a system which would allow judges to act independently and impartial because of the needs of the society and the citizens, and now even more for international community. So it puts judges in a position to be extremely cautious of their duties, but no proper judicial system can only rely on the individual ability of judges to protect, follow, and serve to the public in an independent and impartial way. The state, and I mean legislature and executive power, must, in the interest of their citizens and in the present time in the interest of international community, to create such legal environment on the highest level to enable judges to be independent, to be impartial, and to be trusted by the society. As independence is conditio sine qua non of any standard of a judicial profession, it could be stated that, and I hope that you will agree with me, that independence of judiciary has 2 dimensions. First, one is a procedural one, where rules of procedure, rules of recusal, rules of natural judge, and assurance the judge will act equally in all cases towards all the parties. Second element is the political one, in broader sense of that term. Perhaps one could be surprised how we can speak about political dimension of independence of judiciary, and that it's contradictio in aecto to the connect political system and independence of justice. That link is, the link is there that politics through the legislator and through the executive power creates a frame for proper functioning of the judiciary. If politics decides not to follow standards of independence of judges, it will be difficult to speak about independence of judiciary. Main elements, among others, of political dimension are demonstrated through the system of appointment of judges, security of tenure, working conditions, disciplinary, criminal, and civil liability of judges. EU law doesn't speak much about the independence of judiciary. Only Article 47 of EU Charter of Fundamental Rights speaks about that. I'm not going to read all of it now because you are pretty aware of it. But the essence is that rights of citizens cannot be protected if we do not have independent and impartial tribunal, independent and impartial judges, and independent and autonomous justice system. Coming back to the elements of independence of the judiciary and judges, first one is the system of appointment. From CCJE opinion number 1, paragraph 45, to CCJE opinion number 10, and Council of Ministers recommendation 2010-12, it is beyond any reservation that judges should be appointed by the specific body, Judicial Council, where at least one half of the members should be judges elected by their peers without any interference from political authorities of judicial hierarchy. The same path should be followed when selection and appointment of presidents of courts is in question, as is stated in CCJE opinion number 19. Of course, any decision concerning the selection and career of judges should be based on objective criteria pre-established by law or by the competent authorities. Such decision should be based on merit, having regard to the qualifications, skills, and capacity required to adjudicate cases by applying the law without respecting human dignity. There should be no discrimination against judges or candidates for judicial office of any ground. Coming to the question of terms of office, it is closely connected with the question of irremovability of judges. From UN Basic Principles of Independence of Judiciary, CCJE Opinion Number 1 and Recommendation 2010, fundamental shelter of judicial independence is that tenure is guaranteed until mandatory retirement age, which includes the respect of legal certainty and legal expectations of judges, as it is in brief was stated in cases Volkov against Ukraine or Baka against Hungary. Furthermore, security of tenure and irremovability are key elements of the independence of judges. So the terms of office should be established by law. A permanent appointment should only be terminated in case of serious breaches of disciplinary or criminal provisions established by law or where the judges cannot longer perform judicial functions. Early retirement should be possible only on the request of the judge concerned on the medical grounds. Recommendation 2012, paragraph 50. The question of criminal, civil, and disciplinary liability of judges is last but not the least core element of statutes of judges and reflects what are really intentions of state powers towards establishing true independence of judges. Council of Europe standards in this respect are stated in CCJE opinion number 3 and above mentioned recommendation. In regard to criminal liability, judges should be criminally liable in the ordinary law for offenses committed outside of their judicial office, but criminal liability should not be imposed on judges for unintentional failings in the exercise of their functions. As regards civil liability, CCJE considers that, bearing in mind the principle of independence, the remedy for judicial errors should lie in appropriate system of appeals. Any remedy for other failings in the administration of justice, including, for example, excessive delay, lies only against the state. If it is not appropriate for a judge to be exposed to any personal liability, even by way of reimbursement of the state, except in the case of willful default. As regards disciplinary liability, CCJE considers that in each country the state statute or fundamental charter applicable to judges should define as far as possible in specific terms the failings that may give rise to disciplinary sanctions, as well as the procedures to be followed. Any disciplinary proceedings initiated should be determined by the independent authority or tribunal, guaranteeing full rights of defense according to standards of Article 6 of the Convention. When such authority or tribunal is not itself a court, then its members should be appointed by the independent authority with substantial judicial representation chosen democratically by other judges. There are arrangements regarding disciplinary proceedings in each country should be such as allow to an appeal from initial disciplinary body. The sanctions available to such authority in a case of proven misconduct should be defined as far as possible in specific terms by the statute or fundamental charter of judges and should be applied in a proper manner. Regarding the composition of these independent bodies, the CCJE went a little bit more far than the recommendation, saying that at least more than one half of those members should be judges, appointed by judges in some kind of free elections. So it is very compatible to NCAJ opinion. To conclude, and referring to one of my previous speakers, I think that I have a hard belief that choosing the comparative methods for approving any kind of thesis is a very tricky method when you regard to the judiciary, because any example you can find somewhere. So now taking the argument that Ministry of Justice is sitting in the Council of Judiciary in Bulgaria or in Hungary or somewhere else, that is a wrong argument, because wrong examples are not ones we should follow. So in my strong belief, it is better to stick to the common European standards which have been produced after the long debates among different players, and that is the best way to stick to the independence of judiciary. Thank you very much.